Take it easy. Have a good time.
We'll see how much of this I remember.
Hello. Welcome to Financial Insider Weekly. I'm your host, Michael Gray, CPA. My guest today is Jan Besson. And Jan is an attorney who specializes in elder law with the law offices of Besson and Yarborough, located in Los Altos, California. She received her bachelor's degree from the University of California at Berkeley and stuck with Berkeley to get her law degree at Hastings College. Her law practice was founded in 2000. She is a California State Bar Certified Specialist in Estate Planning, Trust and Probate Law, and is a founding trustee for the Silicon Valley Bar Association. Jan is also recognized as an expert in Medi-Cal and Medicaid law and regularly teaches at the California Advocates for Nursing Home Reform Attorney Training Conferences. And so it's not a coincidence that Jan is here because we're going to be talking about Medi-Cal benefits for long-term care today. And as we get started, I have a little caveat or warning, as I always do. First of all, that we're discussing qualifying for Medi-Cal benefits in California. Many of our viewers actually, on YouTube particularly, are out of the state. So the rules vary for Medicaid benefits in other states. In fact, I've been reading some stuff about it in the paper. It's causing some issues.
Significant differences between California and almost the rest of the nation.
Yeah.
And one of the biggest differences that's so present is in California, it's called Medi-Cal, and in the rest of these states, it's called Medicaid.
Right.
And that's the federal name for the program.
Right. So Jan, welcome and thank you for joining me today.
Thank you, Mike, for having me.
Okay, so as we get started, basically the question that we're dealing with is, what if your spouse or, a relative, whatever, needs long-term care, and you either haven't provided for it with long-term care insurance or the benefits are running out for your insurance? How can you protect your family's assets? So that's sort of the overall issue that we're dealing with here.
Exactly.
So Jan, why don't you explain a little bit about what are Medi-Cal benefits as they relate to this area, and why are they important for providing for long-term care for seniors or other individuals?
Sure. I just want to just also lay a foundation here. Medi-Cal has a multifaceted program that deals with community people who are indigent or unable to afford health insurance, and just a myriad of programs. The long-term care program is a very specialized program that deals with elders and disabled who live in a skilled nursing facility as opposed to any other program.
Okay.
So it does not apply to people who are residents in board and care. It doesn't apply to people who are in retirement facilities. It's only skilled nursing facility that covers the residency and room and board as opposed to just the strict medical coverage that Medi-Cal can provide to others.
Okay.
So the reason that people apply and qualify or try to qualify for Medi-Cal benefits is that the cost of nursing home care can be exorbitant. Generally, you're seeing it run between, I'd say, $6,000 to $10,000 a month for fairly basic nursing home care. And if you have acute care, it can run up as high as $24,000 to $40,000 per month.
And then, to put that over 12 months, I mean, we're talking about some real bucks here.
Significant money, and if somebody is relatively young, it's not unusual for some of my clients to reside in a skilled nursing facility for 10 years, though on the average it's 3 or 4 years, but it's not unusual, and it can certainly deplete any resources, and there are lots of provisions in California. California happens to be a very protective state for the Medi-Cal beneficiaries, and have very generous rules in terms of how to qualify and what assets you can retain and what assets you can preserve following the death of an applicant or a recipient of Medi-Cal benefit. So we'll get into that in more detail. So it really is, from Medi-Cal's viewpoint, the payer of last resort. For many people, it is the payer that they choose to use as the last resort because they no longer have any personal insurance, or their resources have been quote unquote depleted.
Okay. So I've heard before that you have to be destitute basically in order to qualify for Medi-Cal benefits. Is that true?
Well, the term destitute is interesting because, in fact, the applicant can have no more than $2,000 of what's called non-exempt or countable resources. So destitute has to do with the qualification eligibility. On the other hand, there are many provisions for retaining assets that are exempt, and there's also provisions for protecting the spouse at home, so that there is an allowance for the spouse, a resource allowance for the spouse at home. So the destitute is a concept rather than an actuality. It is what we do in planning for Medicaid benefit, because there is that overriding rule that the applicant can have no more than $2,000 in non-exempt assets.
Okay. Can you keep your home and still qualify? And what are some of the related concerns during lifetime and after death?
Well, going back to the concept of destitute,
Yes.
and going back to the concept of non-exempt in assets versus exempt assets.
Yes.
For long-term care Medicaid benefits, you're allowed to keep all exempt assets. And that's a fairly broad category of property. But the most common is the home. And regardless of the value of the home, you are permitted to keep that and still qualify for benefits. The issues involved in keeping the home are kind of interesting, because while you're doing the qualification for Medicaid benefits, you also want to look at tax implications for possible subsequent sale. Certainly you can rent the property while you're in the skilled nursing facility. There has to be an intention to return home, but that in order to keep the exemption for the home. However, the intention to return home is not an objective standard. It doesn't mean that you have the ability. The standard is if you were well, if you had the resources, if your life was perfect, would you live there? And if the answer is yes, or on behalf of the applicant, if the applicant can't answer that question, if it's yes, then the property is exempt. And it remains exempt for as long as you say, yes, if my life was perfect and everything was fine, I would live at home. I wouldn't choose to live here. The other aspect that you're looking at when you retain exempt property, like a home, is what happens to that property after death.
Right.
And what happens to anything that a Medi-Cal beneficiary retains during their lifetime and still has an interest in, and I want to talk about that interest, but still owns at their lifetime, the Department of Health Care Services has the right to assert a claim. And the claim is not mature until you die, and it's not even accruing. It is simply out there, kind of, they're counting what it will be. But the maximum it can be is what the applicant owned at the time of their death, and limited by the amount of Medicaid benefits that were paid on their behalf. So if somebody has $1 million home and they received $50,000 in Medicaid benefits, then the state can only recover $50,000. If they had $1 million home but didn't own it at the time of their death, then that $50,000 claim is, you can't satisfy it, and so the department waives it. They say if you ever have it again, of course you've died, then you can pay it. But,
I see. Okay.
okay.
Do you have to exhaust all of your retirement benefits in order to qualify for Medi-Cal?
Retirement benefits are a form of an unavailable asset, and they are the principle of the retirement benefits, which is kind of a hard definition, but if you think of that which is in your account during the year, that is unavailable to you so long as you're drawing income from the retirement benefit. For people who are not yet 71 and a half and are not yet drawing on their minimum distributions, the income, the definition of income is very vague, because clearly there's no real income with retirement benefits until you draw it out. So there are different ways that you can set it, and it can be a very minimum amount. If you take it on an annual basis, it's annuitized over the whole year, but you do have to start withdrawing. If you're already drawing minimum distributions, then that's the minimum you must withdraw. So there's no real reason to go beyond the minimum distribution if you have retirement benefits. The other thing about retirement benefits, so the principal is not counted. It's also not recoverable on your death. There are a few things that are not recoverable, and retirement benefits are one of those. So.
Okay. So what other assets can you retain?
Well, there are a number of assets, and some of them are quite specific. For example, you can have term insurance, term life insurance. So oftentimes in the process of qualifying for Medi-Cal benefits, while whole life insurance can be a countable, non-exempt asset, term insurance is an exempt asset. So people sometimes convert their whole life to a term insurance plan in order to preserve those assets. You can own a funeral contract, an irrevocable funeral contract to pay for needs, funeral needs, and that can be for you, your spouse, and your immediate family. You can maintain $1,500 in a savings account that's used for those funeral and burial expenses that are not covered by the funeral cost. Your car, as long as it's one car, that can be used for medical purposes, whether it is or not is another issue, so one car is an exempt asset. There's some rules about other real property that will, there are times when people have property that may be fairly heavily mortgaged. You can save a portion of that. You can retain anything that is co-owned and the co-owner refuses to sell. So, I mean, those are just some
Yeah.
of and it goes on, and it's a very long list
Okay.
of expressly exempted assets.
Okay. So if you get over these limits or whatever, now you've got assets that could be exposed. Is there anything that you can do, or maybe in preparation, or maybe even looking forward to this, having to deal with this?
There's quite a bit you can do, and this is where you really need to see somebody who knows what the rules are. California is one of the very few states that continue to allow gifting of property. Gifting of property has to be done very carefully and under a plan. Sometimes people think that just giving your property away is immoral or underhanded or deceitful. It's not. It is permitted. There are statutes that provide what happens if you give away your property. There is a quote-unquote punishment for giving away property, and that punishment is that you are denied long-term care benefits, only long-term care benefits, for a period of time, what those assets would have paid for. In California, these gifts are evaluated individually for that penalty period, and they are not aggregated with any other gifts. So there can be multiple gifts to multiple people on the same day. And so there's a very significant and careful planning that you would want to do if you choose to gift property. There's lots of other ways to convert exempt. What you're doing is reducing your non-exempt property by making it exempt. So like I indicated before, a whole life policy can be converted to a term policy, and now you've taken a non-exempt property, converted it, changed its character so it's non-countable. So there's a lot of that that you can do. Again, that's highly specialized and it's unique for each person. One of the things that we didn't talk about yet was when you have a spouse that is not on Medi-Cal and not in a skilled nursing facility. In those circumstances, the spouse gets to keep an amount of resources, property, non-exempt property, about $120,000 thereabouts. And that number, the amount that a spouse can keep, can be increased based on need. And so that's another aspect of the evaluation I do as an attorney in helping somebody who is at home be able to retain enough benefits to support him or herself while their spouse is in the skilled nursing facility. So there's a broad spectrum of opportunities to have the spouse or the individual in the nursing home be destitute without really being destitute. One of my big concerns when I do this gifting program or transfers of assets is to be sure that there is a mechanism so that even though the Medi-Cal beneficiary is destitute, they are not without protection. And there are a number of ways to protect the spouse, the applicant, beneficiary.
Okay. Are there considerations related to Medi-Cal if you have a disabled child?
It's almost that the rules are off when you have a disabled child. If you have a disabled child, you can set trusts up in any amount for that disabled child or purchase things for them. And all of those assets are not a gift under the penalty rules for eligibility. So if you have a disabled child, the planning gets very easy. though it's complicated, because if you have one disabled child, you don't want to turn your whole estate over to the disabled child if you have other children as well,
Right.
or spouse or whatever, but there are mechanisms to be able to qualify. In addition, there's a special rule that says if you're survived by a disabled child who survives the claim, notice of claim, then there is no recovery against your estate. So whatever you owned, if you kept the house in your name, then that would not be recovered. The Department of Health Care Service wouldn't ask for a repayment of the costs that they incurred on your behalf.
Okay. Is there any significance to the order of death of the spouses? You know, what if the spouse who lives in the home dies first?
Well, what you're discussing at that point is usually, I think we're talking about the time when you already have somebody in the skilled nursing facility,
Right.
and then and has qualified for benefits, and then the at-home spouse dies first. There are rules that can protect those assets. One of the most fundamental rule is anything that passes to the Medi-Cal beneficiary under a will and is in a trust, like a special needs trust. And what a special needs trust is, a very restrictive trust where the beneficiary doesn't have the right to demand distributions, but the assets can be used for their benefit. If it's funded, created and funded under a will, those then become exempt assets. On the other hand, if the spouse has not done a comprehensive estate plan to protect those assets, dies intestate, and has a couple of children, then the children will receive a portion of those. The Medi-Cal beneficiary will receive a portion of the estate and would end up being disqualified from Medicaid benefits. So you want to make sure that as part of the plan for a couple or anybody, that an estate plan is developed along with the plan for qualifications.
Okay. If you're on Medi-Cal, how much do you have to pay each month?
The amount you have to pay each month is the income of the Medi-Cal beneficiary, not the income of the spouse. Anything that's paid that is name on the check rule, if it goes to the spouse, it's the spouse's, the non-Medi-Cal beneficiary spouse. So it's called a share of cost. It's like a monthly deductible that you have to meet every month, and it's based on your income, less a few deductions, such as your health care premiums and $35 and those kinds of exceptions. Generally, if there's need, there are mechanisms to reduce that share of cost to zero based on your spouse's income. And you can generally do that through court. You can do it by retitling investment property. And so those kinds of opportunities.
Okay. So maybe we could just remind people that when do these benefits have to be repaid?
The benefits are repayable. This is called the recovery claim, and this is also an aspect of Medicaid planning, Medi-Cal planning. The benefits have to be repaid on the death of the Medi-Cal beneficiary unless there's a surviving spouse, and then that claim is deferred until the surviving spouse's death, and it is limited to what the Medi-Cal beneficiary owned at the Medi-Cal beneficiary's death. So you never go beyond what the Medi-Cal beneficiary owned. So as long as there's a surviving spouse, a disabled child, a minor child in the house at the time of the Medicaid beneficiary's death, there is no recovery at that time. There's a piece of legislation out there right now that is in front of the legislature in which they're looking at waiving all claims permanently for a Medicaid beneficiary who has a surviving spouse. So there's no second claim. That is not law. It's not in place, but it shows that the legislature is looking at ways to protect the beneficiary, the spouses
family,
and the family.
Okay. So, have about a minute. Maybe you
Okay.
can throw out a final thought.
Well, there is a final thought, and that is the Medi-Cal laws are in constant flux. It's something you have to really keep up on. There are myriad of laws, myriad of regulations, little ways in which they do things that you have to be aware of. Otherwise, you can violate those rules and end up not having a long-term care plan. So that's important to make sure that you're working, if you're looking for Medi-Cal eligibility for long-term care or in planning for it, you need to have the proper provisions in your estate. You're healthy, you're developing an estate plan. If you want to plan for long-term care, you need to have those provisions in your estate planning documents so that you don't need to go to court. So there's ways to anticipate it, to avoid all the costs of court, but the planning should be done with somebody who is very clearly aware of the current regulations regarding Medi-Cal benefits.
Okay, Jan. Well, we're about out of time. I want to thank you so much for joining me today,
Thank you,
sharing
Mike.
a little bit about this very important topic. A lot of people think, this could never apply to me, but it's an option that most people, I think, need to at least have a contingency plan for if something happens. Because it's amazing how assets can vanish when you have these high healthcare costs. I mean, we talked a little bit about what these monthly costs can be. I mean, it can consume your assets pretty quickly. Folks, we're all out of time. Thanks so much for joining us. We'll see you next time on Financial Insider Weekly.